My dear and respected friends, my colleagues in legal profession, fellow citizens, members of civil society, and defenders of democracy and constitution, today I am before you not merely to speak about technology, not merely to discuss laws, but to speak about the future of our constitutional democracy because of the recent developments with respect the steps taken by the central government, that is the Digital Personal Data Protection Act 2023, Sanchara Sarathi app, and amendments to the Right to Information Act, etc. My friends, India did not become a republic merely to hold elections. We became a republic in 1950 and when we gave ourselves a constitution that guaranteed freedom of speech under Article 19, Clause 1, Subclause A, right to life and personal liberty under Article 21, equality before law under Article 14. And in the year 2017, in historic judgment, Justice K.S. Puttaswamy versus Union of India, the Supreme Court declared that privacy is the fundamental right, intrinsic to the dignity, autonomy, and liberty. But today we must ask, are we strengthening that constitutional promise, or are we slowly surrendering it? The rise of a digital surveillance framework. Let us begin with Sanchar Sarathi. This platform, presented as a citizen-friendly telecom service, enables centralized access to SIM and telecom data. But we must understand, telecom metadata is not trivial information. It reveals whom you speak to, when you speak, and where you are located. Your network of associations and metadata maps your life. Without strict judicial oversight, time limits, transparency, and independent review, such centralized data systems create the architecture of surveillance. Surveillance does not begin with arrest, it begins with silent monitoring. And silent monitoring produces silent citizens. My friends, the Digital Personal Data Protection Act 2023, whether it is a protection or permission. When government introduced the Digital Personal Data Protection Act 2023, DPDP Act 2023, citizens expected a strong privacy shield after the Puttaswamy judgment. But what did we receive? Broad exemptions for the state in the name of security and public order, no meaningful independent regulator, weak remedies for citizens, limited transparency about how government agencies process data, a privacy law that exempts the government from accountability is not a shield. It is a shield with holes. Privacy is not anti-national, my friends. Privacy is constitutional. Then control over social media and digital expression. Next, we see the increasing regulatory pressure on social media platforms. Traceability mandates that undermine inscription. Government-directed takedowns. Compliance mechanisms that incentivize over censorship. The right to free speech under Article 19 includes the right to dissent. Democracy does not mean uniformity of opinion. It means diversity of voices. When speech is monitored and platforms fear penalties, citizens begin to self-censor. Self-censorship is the invisible death of democracy. Dilution of right to information. My friends, the Right to Information Act empowered ordinary citizens to question the powerful, but amendments have reduced the independence of information commissioners. Transparency mechanisms are weakening. Without transparency, surveillance expands unchecked. Without information, accountability disappears. And democracy without transparency becomes governance without scrutiny. So the dangerous convergence. My friends, any of these measures might be defended separately and in isolation, but together they form a pattern. State access to vast data pools, weak privacy safeguards, increased content regulation, reduced transparency, and a climate where dissent is viewed with suspicion. This convergence transforms the relationship between citizens and state. In a constitutional democracy, the state is accountable to the citizen. In a surveillance state, the citizen is exposed to the state. That inversion is dangerous. Then what are the constitutional standards? The Constitution permits reasonable restrictions. Yes, but restrictions must be lawful, necessary, proportionate, and subject to judicial review. Mass data access without oversight fails proportionality. Content separation without transparency fails reasonableness. And my friends, now the days which we are now witnessing this right to freedom of speech and includes right to dissent, my friends. So the amendments which were carried out to the Right to Information Act and the reducing the powers of the information commissioners, and without transparency, my friends, surveillance expands unchecked. Without information, accountability disappears. A democracy without transparency becomes governance without scrutiny. So this is, my friends, this is very dangerous then. My friends, of course, mass data access without oversight fails proportionality, fails. Content suppression without transparency fails reasonableness. Broad exemptions violate equality under Article 14. Even under international law includes ICCPR, surveillance must be narrowly tailored. Blanket or vague powers do not meet constitutional standards. My friends, why this matters to every citizen? Some may think I have nothing to hide, but privacy is not about hiding wrongdoing. It is about protecting the dignity. It is about protecting political choice. It is about protecting thought before it becomes speech. If citizens feel watched, they hesitate to question. If they hesitate to question, power becomes unchecked. Unchecked power corrodes the democracy. And what must be done? We must demand stronger judicial oversight over surveillance mechanisms, seek amendments to strengthen data protection safeguards, restore independence to transparency institutions, protect inscription and anonymous speech, support public interest litigation defending fundamental rights, build awareness in universities, legal forums, and civil society. The Constitution survives only when citizens defend it and stand by it. Conclusion. My friends, democracy does not collapse overnight. It erodes gradually through small legal shifts, silent administrative powers, and normalization of surveillance. We must ask ourselves, are we citizens of a constitutional democracy or subjects of a monetary republic? The Constitution begins with the words, we the people of India, not we the government, not we the administrators, but we the people. If we remain informed, vigilant, and united, privacy will survive, dissent will survive, and democracy will survive. Let us defend our Constitution, not with anger, but with awareness, not with fear, but with courage, not with division, but with constitutional conviction. Jai Bharat, Jai Constitution. Thank you.